BO Properties versus is it Delgina Little?
Your
Yes,
Honor,
I'm here.
my name is Matthew Lafferty. I'm a student attorney requesting permission to speak on Delgina's behalf under Rule 8.120.
Okay. I don't have the time, but that was really messed up how you did that. I'll let your supervisors deal with that. Permission to practice is granted. Is there somebody else? Is there another student attorney that needs to ask?
Yep.
Yes, Your Honor. Samuel Portinga, student attorney, requesting permission to appear under Rule 8.120 under Allison Friedman's supervision.
Again, you both are together messing it up. All right. You request permission to practice under Michigan Court Rule 8.120 under the supervision, and then you give the name of your supervisor.
Thank you.
This time I will allow it, and I will allow permission to practice. All right. Where
Thank you, Your Honor.
are we on this case? This was
You don't want to ask where they're from? Don't you usually ask where they're from?
I was going to. I was trying to get through this, but I'll ask where they're
That's
from.
no.
No.
I don't want to mess up your mojo.
You're right. You are right, Mr. Miller, and I don't want to have them feel left out, even though they blew the introduction. Mr. Lafferty, where are you from?
Thank you, Your Honor. I was looking forward to this question. I was prepared for this question. I am from Virginia originally, but I love Michigan.
All right, Virginia.
Wrong answer, Judge. I think
Yeah.
you should not be allowed to practice.
Right. Where'd you go to undergrad?
University of Florida.
Well, that's even worse. All right. You almost,
record.
how close were you to Maryland when you were in Virginia?
Fairfax County, till it's about 9 years old.
So Fairfax?
Yeah.
So
yeah.
you were close. Okay, I'll let you practice. All right.
Thank you.
And you, young man, where are you from?
I'm originally from Grand Rapids, Michigan.
So a Michigander.
Yes, sir.
All right. Where'd you go to undergrad?
I went to Calvin.
Very good. All right. Since you're a Michigander, you can stay. I'll let them both stay. All right.
No objection, Your Honor.
All
To the Michigander, at least.
Yes. All right. Where are we on this case?
Your Honor, last time we were here, there were some documents that needed to be submitted for the SEER application. On February 23rd, those documents were submitted along with the worksheet for approval. We haven't heard back from the caseworker, but they were ready to go as soon as we hear back.
Mr. Lee.
Your Honor, I think the caseworker was not aware that this case had a pending court case. It was approved with a settlement statement, not a COD. So I think the check has already been issued. I do have the amount. They have been approved for $1,345 for 6 months of rent arrears, and they are receiving $660 for 3 months. So the total amount is going to be $2,005.
So just for Your Honor's notification, right now our claim is for $1,859. So assuming that comes, that would cover the back balance.
Pardon?
Oh, you didn't hear me? I'm sorry.
No.
$1,859 is our current arrearage. So the payment would cover that, assuming it arrives.
All right.
Miss Lee, would you be able to send us that worksheet or whatever was done? Because we didn't receive any of the paperwork, and I don't believe Miss Little did either.
Yes, I can do that.
Thank you.
Okay. So what do you want me to do with this? Just a week out? Or
I think you should put it over to the 18th, and we'll see what happens.
okay. Any objection? You guys don't even know what I mean. Never mind. March 18th, 2022.
No objection, Your Honor. Thank you.
Thank you. 9 a.m. They're just starstruck seeing me. I get it. Okay. All right.
Thank you, Your Honor. We'll see you next week.
Thank you, gentlemen.
Thank
He
you,
signs
Your Honor.
autographs if you want to come visit.
Okay. All right, guys. Take care. Three Oaks Properties versus Timothy Nagel.
Good morning, Mr. Honor. Your Honor, my name is Matthew Lafferty. I'm a student attorney at the University of Michigan Law School, and I am requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Allison Friedman.
And good morning, Your Honor. The student attorney Samuel Portinga requesting permission to appear on behalf of Mr. Nagel under Michigan Court Rule 8.120, also under Allison Friedman supervision.
All right. Have you guys appeared before me? I'm getting
Yes, sir.
I thought so. All right. All right. Where are we on this?
Your Honor, we just received this case. There was an alleged habitability issue in our client's apartment. We've been out to that apartment. The habitability issue has been cured. To the best of my knowledge, Your Honor, we also have an issue potentially with the heating in this unit, and we are asking permission for limited discovery to get more information.
What? Okay. So you say there's a heating issue?
Well, Your Honor, in the complaint, they alleged that there was a serious or continuing health hazard. And we've been out to this apartment, and our client has taken remedial actions since hearing about this health hazard. The apartment's been cleaned, it's been disinfected. We are in the process of, learning more about the situation from the landlord. And if there is a habitability issue here, we ask that some reasonable accommodation be made for our client. He suffers from an anxiety disorder and from a hoarding disorder, which are protected under the Fair Housing Act. So we request reasonable accommodations. He's being asked to leave, and we are asking for some time to get a sense for this case.
Mr. Friedman.
Your Honor, first of all, this is now 2 years in, and I have filed another complaint, as I told you I would, under a 30-day termination for the lease violations. As far as the reasonable accommodation is concerned, we're not interested in accommodating his bugs. They are disturbing the rest of the building. The rest of the building is asking for an accommodation, i.e. him moving. So I'm not interested in fooling around too long with this. So if they want to get me discovery, I'll get them an answer. And let's use that April 8th date. And as a control date, I'll get them their discovery immediately.
Any objection to adjourning this out to April 8th?
No objection, Your Honor.
No objection.
Mr. Fretman, may I just inquire as to whether you received our reasonable accommodations letter?
Well, I haven't gotten it today. I haven't seen it, but if you'll email it to me, I'll be able to take a look at it. I'm in my Florida office right now.
No problem. We have sent it to your email, so I just request that you take a look at it and let us know if you are going to proceed under reasonable accommodations or if we'll need to take other measures.
Well, I'm pretty sure you're going to have to take other measures because we can't accommodate his roaches.
All righty then. So why don't I adjourn this April 8th, 2022 at 9 a.m. All right.
Thank you, Your Honor.
Not the roaches. Oh my God.
Thank you.
It started like any ordinary courtroom session. But nothing about this day would be ordinary. Two student attorneys, Matthew Lafferty and Samuel Portinga, stepped before the judge to represent their clients. Simple enough, right? Wrong. They fumbled their very first introduction, the basic required speech under Michigan Court Rule 8.120, not once, but twice. The judge's reaction, pure, barely contained disbelief. That was really messed up how you did that, the judge said flatly, Abaduram, and the room felt it. But the judge, in a moment of unexpected warmth, softened slightly and asking where each attorney was from. Matthew, Virginia, law school, University of Florida. The judge's response was priceless. That's even worse. Samuel, however, was from Grand Rapids, Michigan, and suddenly all was forgiven. Michigan loyalty runs deep in this courtroom. Then came the real drama. The second case, Three Oaks Properties versus Timothy Nagel, Somsensim, was a powder keg. A tenant with anxiety disorder and hoarding disorder, both protected under fair housing law, had been battling eviction for 2 full years. His student attorneys argued habitability violations. a heating issue, and pushed for reasonable accommodations. They even sent a formal accommodation letter. The landlord, completely unmoved. "We can't accommodate his roaches," he said, cold and direct, and that line landed like a grenade. The judge adjourned to April 8th, giving both sides time to respond to discovery. But with $2,005 in Sierra housing funds potentially covering the arrearage and a reasonable accommodation letter hanging in the air unanswered, this case is far from over. The tenant's fate rests on whether disability law will protect him, or whether the landlord's patience, and the judge's, has finally run out. What would you have ruled? Let us know below. Justice is still watching.